Hello, good evening to everybody. This is Advocate Arun from Chennai. Today I am going to explain certain legal terminologies which may appear confusing to a common man who is not well vested in the branch of law. So, let me explain the concept called precedent today. What is a precedent? Precedent is basically a judge-made law. The concept evolved in England through the House of Commons, judgments rendered before House of Commons. It disevolves over the period of time to say that there should be certain consistency. Basically, the concept of precedence is there to prevent inconsistency in rendering justice. For example, if a court of law is deciding a particular point of law today, if the concept of precedent is not there, then what will happen? Then another court of law, another court will decide the same set of facts, decisions, same cause of action in a different way, and so on and so on. So what will be the end result of it? There will be total confusion, and nobody knows what is the correct proposition of law. In order to prevent that from happening, the concept of precedent evolved. Precedence is nothing but creating a consistency as well as judicial administration is concerned. For example, if we take a decision of Supreme Court India, all decisions are rendered by Supreme Court according to Article 142 of Constitution of India is the law of the land as declared by Supreme Court of India. It should be applicable to throughout the territory of India in each courts and tribunals established under an Act of Parliament or as per the Constitution. So, no authority can act in derogatory to the decisions rendered by Supreme Court. So that is called the concept of precedence. There may be certain exception to the rule. Most important exception is the concept of determining a judgment as per-incuriam. What is per-incuriam? Per-incuriam is a concept in which a superior court or coordinate bench of the same court decides that the earlier decision rendered by it is per-incuriam in nature, as that earlier decision doesn't take into consideration earlier binding precedent rendered by Supreme Court or other higher forum, and therefore the earlier judgment which rendered in ignorance of earlier binding precedent is not a good proposition of law. That is called concept of per-incuriam. The per-incuriam concept means would be raised by several persons before court of law to demonstrate that the judgment which was cited by the opposition party is invalid for the reasons that that judgment doesn't take into consideration earlier binding precedent. Basically, this concept runs down to two aspects. A judgment can be straightaway called judgment in per-incuriam when it expressly disregards orders of the Honorable Supreme Court, precedents of the Honorable Supreme Court, and proceeded to decide the case in a given case contrary to what Supreme Court says. There may be another scenario in which this court, there was an earlier judgment of the same court giving a different interpretation to a given case of law, and thereafter the judgment decided by the same court, the same bench decides the case This is another case which arises in the same cause of action in a different way. Then, according to the ruling of the Supreme Court of India, it says the earlier judgment as well as the later one, which gives two contrary view in a given set of facts, will stand as it until a higher forum accepts either of the judgment as laying down the correct proposition of law and overruling the other judgment as bad in law. Until such time, both the judgments will stand still. So, you may remember, you may observe what I am trying to tell to the audience at large. Basically, precedence is a complex concept which evolves in England and which we accepted as in Indian judicial system to create a consistency as far as decisions of courts are concerned. So another day we can explain regarding another subject, which I will definitely do. Therefore, hereafter, let me say goodbye to everybody else. Thank you.